Hello, everyone. Today we're going to be reading Northwest Austin Municipal Utility District Number 1 versus Holder. This is regarding the Voting Rights Act, specifically the bailout provision and subsection 5. So, the is a small utility district with an elected board. Because it is located in Texas, it is required by subsection 5 of the Voting Rights Act of 1965 Act to seek federal preclearance before it can change anything about its elections, even though there is no evidence it has ever discriminated on the basis of race in those elections. The district filed suit seeking relief under the bailout provision in subsection 4A of the Act, which allows a political subdivision to be released from the preclearance requirements if certain conditions are met. The district argued in the alternative that if subsection 5 were interpreted to render it ineligible for bailout, subsection 5 was unconstitutional. The federal district court rejected both claims. It concluded that bailout under subsection 4A is available only to counties, parishes, and subunits that register voters, not to an entity like the district that does not register its own voters. It also concluded that a 2006 amendment extending subsection 5 for 25 years was constitutional. Held. The historic accomplishments of the Voting Rights Act are undeniable, but the Act now raises serious constitutional concerns. The preclearance requirement represents an intrusion into areas of state and local responsibility that is otherwise unfamiliar to our federal system. Some of the conditions that the court relied upon in upholding this statutory scheme in South Carolina versus Katzenbach and City of Rome, the United States, have unquestionably improved. Those improvements are no doubt due in significant part to the Act itself and stand as a monument to its success. But the Act imposes current burdens that must be justified by current needs. The Act also differentiates between the states in ways that may no longer be justified. At the same time, the court recognizes that judging the constitutionality of an act of Congress is the gravest and most delicate duty that this court is called on to perform. Here, the district court found that the sizable record compiled by Congress to support extension of subsection 5 documented continuing racial discrimination, and that subsection 5 deterred discriminatory changes. The court will not shrink from its duty as the bulwark of a limited constitution against legislative encroachments. But it is well established that normally the court will not decide a constitutional question if there is some other ground upon which to dispose of this case. Here, the district also raises a statutory claim that it is eligible to bail out under subsections 4 and 5, and that claim is sufficient to resolve the appeal. The act must be interpreted to permit all political subdivisions, including the district, to seek the bailout from the preclearance requirements. It is undisputed that the district is a political subdivision in the ordinary sense, but the act also provides a narrower definition in subsection 14C2. Political subdivision shall mean any county or parish except that where registration for voting is not conducted under the supervision of a county or parish. The term shall include any other subdivision of a state which conducts registration for voting. The court below concluded that the district did not qualify for subsection 4A bailout under this definition, but specific precedent, the Act's structure, and underlying constitutional concerns compel a broader reading. This court has already established that subsection 14C2's definition does not apply to the term political subdivision in subsection 5's preclearance provision. Rather, the definition was intended to operate only for purposes of determining which political units in non-designated states may be separately designated for coverage under subsection 4B. Once a state has been so designated, the definition has no operative significance in determining subsection 5's reach. In light of these decisions, subsection 14C2's definition should not constrict the availability of bailout either. The government responds that any such argument is foreclosed by City of Rome. In 1982, however, Congress expressly repudiated City of Rome. Thus, City of Rome's logic is no longer applicable. The government's contention is that the district is subject to subsection 5 under Sheffield, not because it is a political subdivision, but because it is a state, is counterintuitive and similarly untenable after the 1982 amendments. The government's contrary interpretation has helped to render the bailout provision all but a nullity. Since 1982, only 17 jurisdictions out of more than 12,000 covered political subdivisions have successfully bailed out of the act. It is unlikely that Congress intended the provision to have such limited effect. Reversed and remanded. Chief Justice Roberts delivered the opinion of the court, in which Stevens, Scalia, Kennedy, Souter, Ginsburg, Breyer, and Alito joined. Thomas filed an opinion concurring in judgment in part and dissenting in part. This is where's the opinion? Chief Justice Roberts delivered the opinion of the court. The plaintiff in this case is a small utility district raising a big question: the constitutionality of subsection 5 of the Voting Rights Act. The district has an elected board and is required by subsection 5 to seek preclearance from federal authorities in Washington, D.C. before it can change anything about those elections. This is required even though there has never been any evidence of racial discrimination in voting in the district. The district filed suit seeking relief from these preclearance obligations under the bailout provision of the Voting Rights Act. That provision allows the release of a political subdivision from the preclearance requirements if certain rigorous conditions are met. The court below denied relief, concluding that bailout was unavailable to a political subdivision like the utility district that did not register its own voters. The district appealed, arguing that the act imposes no such limitation on bailout and that if it does, the preclearance requirements are unconstitutional. The constitutional question has attracted ardent briefs from dozens of interested parties, but the importance of the question does not justify our rushing to decide. Quite the contrary, our usual practice is to avoid the unnecessary resolution of constitutional questions. We agree that the district is eligible under the Act to seek bailout. We therefore reverse and do not reach the constitutionality of subsection 5. The 15th Amendment promises that the right of citizens of the United States to vote shall not be denied or abridged on account of race, color, or previous condition of servitude. In addition to that self executing right, the amendment also gives Congress the power to enforce this article by appropriate legislation. The first century of congressional enforcement of the amendment, however, can only be regarded as a failure. Earlier enforcements of the acts were inconsistently applied and repealed with the rise of Jim Crow. Another series of enforcement statutes in the 1950s and 1960s depended on individual lawsuits filed by the Department of Justice. The litigation is slow and expensive, and the states were creative in contriving new rules to continue violating the 15th Amendment in the face of adverse federal court decrees. Congress responded with the Voting Rights Act. Section 2 of the Act operates nationwide as it exists today. That provision forbids any standard practice or procedure that results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color. Section 2 is not at issue in this case. The remainder of the Act constitutes a scheme of stringent remedies aimed at areas where voting discrimination has been most flagrant. Rather than continuing to depend on case by case litigation, the Act directly preempted the most powerful tools of black disenfranchisement in the covered areas. All literacy tests and similar voting qualifications were abolished by subsection 4 of the Act. Although such tests have been facially neutral, they were easily manipulated to keep blacks from voting. The Act also empowered federal examiners to override state determinations about who was eligible to vote. These two remedies were bolstered by subsection 5, which suspended all changes in state election procedure until they were submitted to and approved by a three-judge federal district court in Washington, D.C., or the Attorney General. Such preclearance is granted only if the change neither has the purpose nor will have the effect of denying or abridging the right to vote on account of race or color. We have interpreted the requirements of subsection 5 to apply not only to the ballot access rights guaranteed by subsection 4, but to drawing district lines as well. To confine these remedies to areas of flagrant disenfranchisement, the Act applied them only to states that had used a forbidden test or device in November 1964 and has less than 50% voter registration or turnout in the 1964 presidential election. Congress recognized that the coverage formula it had adopted might bring within its sweep governmental units not guilty of any unlawful discriminatory voting practices. It therefore afforded such jurisdictions immediately available protection in the form of a bailout suit. To bail out under the current provision, a jurisdiction must seek a declaratory judgment from a three-judge district court in Washington, D.C. It must show that for the previous 10 years it has not used any forbidden voting test, has not been subject to any valid objection under subsection 5, and has not been found liable for other voting rights violations. It must also show that it has engaged in constructive efforts to eliminate intimidation and harassment of voters and similar measures. The Attorney General can consent to entry of judgment in favor of bailout if the evidence warrants it, though other interested parties are allowed to intervene in the declaratory judgment action. There are other restrictions. To bail out, a covered jurisdiction must show that every jurisdiction in its territory has complied with all of these requirements. The district court also retains continuing jurisdiction over a successful bailout suit for 10 years and may reinstate coverage if any violation is found. As enacted, subsections 4 and 5 of the Voting Rights Act were temporary provisions. They were expected to be in effect for only 5 years. We upheld the Temporary Voting Rights Act of 1965 as an appropriate exercise of congressional power in Katzenbach, explaining that the constitutional propriety of the Voting Rights Act of 1965 must be judged with reference to the historical experience which it reflects. We concluded that the problems Congress faced when it passed the act were so dire that exceptional conditions could justify legislative measures not otherwise appropriate. Congress reauthorized the act in 1970 for 5 years, 1975 for 7 years, and 1982 for 25 years. The coverage formula remained the same based on the use of voting eligibility tests and the rate of registration and turnout among all voters. But the pertinent dates for assessing these criteria moved from 1964 to include 1968 and eventually 1972. We upheld each of these reauthorizations against constitutional challenges, finding that circumstances continued to justify the provisions. Most recently, in 2006, Congress extended subsection 5 for yet another 25 years. The 2006 Act retained 1972 as the last baseline year for triggering coverage under subsection 5. It is that latest extension that is now before us. Northwest Austin Municipal Utility District Number 1 was created in 1987 to deliver city services to residents of a portion of Travis County, Texas. It is governed by a board of 5 members elected to staggered terms of 4 years. The district does not register voters but is responsible for its own elections. For administrative reasons, those elections are run by Travis County. Because the district is located in Texas, it is subject to the obligations of subsection 5, although there is no evidence that it has ever discriminated on the basis of race. The district filed suit in the district court for the District of Columbia, seeking relief under the statute's bailout provisions and arguing in the alternative that, if interpreted to render the district ineligible for bailout, subsection 5 was unconstitutional. The three-judge district court rejected both claims. Under the statute, only a state or political subdivision is permitted to seek bailout, and the court concluded that the district was not a political subdivision because that term includes only counties, parishes, and voter registration subunits. During the district's constitutional challenge, Turning to the district's constitutional challenge, the court concluded that the 25-year extension of subsection 5 was constitutional both because Congress rationally concluded that subsection 5 was necessary to protect minorities from continued racial discrimination in voting, and because the 2006 amendment qualifies as a congruent and proportional response to the continuing problem of racial discrimination in voting. We noted probable jurisdiction and now reverse. The historical accomplishments of the Voting Rights Act are undeniable. When it was first passed, unconstitutional discrimination was rampant, and the registration of voting age whites ran roughly 50 percentage points or more ahead of black registration in many covered states. Today, the registration gap between white and black voters is in single digits in the covered states, and in some of those states, blacks now register and vote at higher rates than whites. Similar dramatic improvements have occurred for other racial minorities. Many of the first generation barriers to minority voter registration and voter turnout that were in place prior to the Voting Rights Act have been eliminated. At the same time, subsection 5, which authorizes federal intrusion into sensitive areas of state and local policymaking, imposes substantial federalism costs. These federalism costs have caused members of this court to express serious misgivings about the constitutionality of subsection 5. Section 5 goes beyond the prohibition of the 15th Amendment by suspending all changes to state election law, however innocuous, until they have been pre-cleared by federal authorities in Washington, D.C. The pre-clearance requirements apply broadly, and in particular to every political subdivision in a covered state, no matter how small. Some of the conditions that were relied upon in upholding this statutory scheme in Katzenbach and City of Rome have unquestionably improved. Things have changed in the South. Voter turnout and registration rates now approach parity. Blatantly discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented levels. These improvements are no doubt due in significant part to the Voting Rights Act itself, and stand as a monument to its success. Past success alone, however, is not adequate justification to retain the pre-clearance requirements. It may be that these improvements are insufficient and that conditions continue to warrant pre-clearance under the Act, but the Act imposes current burdens that must be justified by current needs. The Act also differentiates between the states, despite our historic tradition that all the states enjoy equal sovereignty. Distinctions can be justified in some cases. The doctrine of equality of states does not bar remedies for local evils which have subsequently appeared. But a departure from the fundamental principle of equal sovereignty requires a showing that a statute's disparate geographic coverage is sufficiently related to the problem that it targets. These federalism concerns are underscored by the argument that the preclearance requirements in one state would be unconstitutional in another. Yet considerations of race that would doom a redistricting plan under the 14th Amendment or subsection 2 seem to be what save it under subsection 5. Oh, race cannot be the predominant factor in redistricting under a decision in Miller v. Johnson, yet considerations of race would doom a redistricting plan under the 14th Amendment or subsection 2 seem to be what saved it under subsection 5. Additional constitutional concerns are raised in saying that this tension between subsections 2 and 5 must persist in covered jurisdictions and not elsewhere. The evil that subsection 5 is meant to address may no longer be concentrated in the jurisdictions singled out for preclearance. The statute's coverage formula is based on data that is now more than 35 years old, and there is considerable evidence that it fails to account for current political conditions. For example, the racial gap in voter registration and turnout is lower in the states originally covered by subsection 5 than it is in nationwide. Congress heard warnings from supporters of extending subsection 5 that the evidence in the record did not address systematic differences between the covered and the non-covered areas of the United States. And in fact, the evidence that is in the record suggests that there is more similarity than difference. The parties do not agree on the standard to apply in deciding whether, in light of foregoing concerns, Congress exceeded its 15th Amendment enforcement power in extending the preclearance requirements. The district argues that there must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. The federal government asserts that it is enough that the legislation be a rational means to effectuate a constitutional prohibition. That question has been extensively briefed in this case, but we need not resolve it. The Act's preclearance requirements and its coverage formula raise serious constitutional questions under either test. In assessing those questions, we are keenly mindful in our institutional role. We fully appreciate that judging the constitutionality of an act of Congress is the gravest and most delicate duty that this court is called on to perform. The Congress is a co-equal branch of government whose members take the same oath we do to uphold the Constitution of the United States. The 15th Amendment empowers Congress, not the court, to determine in the first instance what legislation is needed to enforce it. Congress amassed a sizable record in support of its decision to extend the preclearance requirements. A record of the district court determined documented contemporary racial discrimination in covered states. The district court also found that the record demonstrated that Section 5 prevents discriminatory voting changes by quietly but effectively deterring discriminatory changes. We will not shrink from our duty as the bulwark of a limited constitution against legislative encroachments. But it is a well-established principle governing the prudent exercise of this court's jurisdiction that normally the court will not decide a constitutional question if there is some other ground upon which to dispose of the case. Here, the district also raises a statutory claim that it is eligible to bail out under subsections 4 and 5. Justice Thomas argues that the principle of constitutional avoidance has no pertinence here. He contends that even if we resolve the district's statutory argument in its favor, we would still have to reach the constitutional question because the district's statutory argument would not afford it all the relief it seeks. We disagree. The district expressly describes its constitutional challenges to subsection 5 as being in the alternative to its statutory argument. The district's counsel confirmed this at oral argument. We therefore turn to the district's statutory argument. Section 4B of the Voting Rights Act authorizes a bailout suit by a state or political subdivision. There is no dispute that the district is a political subdivision of the state of Texas in the ordinary sense of the term. The district was created under Texas law, which powers of government with powers of government relating to local utilities and natural resources. The Act, however, also provides a narrower statutory definition in subsection 14C2. Political subdivision shall mean any county or parish, except that where registration for voting is not conducted under the supervision of a county or parish, the term shall include any other subdivision of a state which conducts registration for voting. The district court concluded that this definition applied to the bailout provision in subsection 4A, and that the district did not qualify since it is not a county or parish and does not conduct its own voter registration. Statutory definitions control the meaning of statutory words, of course, in the usual case, but this is an unusual case. Were the scope of subsection 4A considered in isolation from the rest of the statute and our prior cases, the district court's approach might well be correct. But here specific precedent, the structure of the Voting Rights Act, and underlying constitutional concerns compel a broader reading of the bailout provision. Importantly, we do not write on a blank slate. Our decisions have already established that the statutory definition in subsection 14C2 does not apply to every use of the term political subdivision in the Act. We have, for example, concluded that the definition does not apply to the preclearance obligation of subsection 5. According to its text, subsection 5 applies only whenever a covered state or political subdivision enacts or administers a new voting practice. Yet in Sheffield Board of Commerce, we rejected the argument by an Alabama city that it was neither a state nor a political subdivision as defined in the Act, and therefore did not need to seek preclearance of a voting change. The dissent agreed with the city, pointing out that the city did not meet the statutory definition of political subdivision and therefore could not be covered. The majority, however, relying on the purpose and structure of the Act, concluded that the definition was intended to operate only for purposes of determining which political units in non-designated states may be separately designated for coverage under subsection 4B. We reaffirmed this we reaffirmed this restricted scope of the statutory definition the next term in Dougherty County Board of Education versus White. There, a school board argued that because it did not meet the definition of political subdivision in subsection 14C2, it did not come within the purview of subsection 5. We responded. The contention is squarely foreclosed by our decision last term in Sheffield. There, we expressly rejected the suggestion that the city of Sheffield was beyond the ambit of subsection 5 because it did not itself register voters and hence was not a political subdivision as the term is defined in subsection 14C2 of the Act. Once a state has been designated for coverage, subsection 14C2's definition of political subdivision has no operative significance in determining the reach of subsection 5. According to these decisions, then, the statutory definition of political subdivision in subsection 14C2 does not apply to every use of the term political subdivision in the Act. Even when interveners who oppose the district's bailout concede, for example, that the definition should not apply to subsection 2, which bans racial discrimination in voting by any state or political subdivision. The Supreme Court has held that this definition in subsection 14C2 limits the meaning of the phrase state or political subdivision only when it appears in certain parts of the Act, and that it does not confine the phrase as used elsewhere in the Act. In light of our holdings that the statutory definition does not constrict the scope of preclearance required by subsection 5, the district argues, it only stands to reason that the definition should not constrict the availability of bailout from those preclearance requirements either. The government responds that any such argument is foreclosed by our interpretation in the statute in City of Rome. There, it argues, we made clear that the discussion of political subdivisions in Sheffield was dictum and specifically held that a city is not a political subdivision for purposes of subsection 14 of subsection 4A bailout. Even if that is what City of Rome held, the premises of its statutory holding did not survive later changes in the law. In City of Rome, we rejected the city's attempt to bail out from coverage under subsection 5, concluding that political units of a covered jurisdiction cannot independently bring a subsection 4A bailout action. We concluded that the statute, as then written, authorized a bailout suit only by a state subject to the coverage formula or a political subdivision with respect to which coverage determinations have been made as a separate unit. Political subdivisions covered because they were part of a covered state rather than because of separate coverage determinations could not separately bail out, as Justice Stevens put it. The political subdivisions of a covered state were not entitled to bail out in a piecemeal fashion. In 1982, however, Congress expressly repudiated City of Rome and instead embraced piecemeal bailout. As part of an overhaul of the bailout provision, Congress amended the Voting Rights Act to expressly provide that bailout was available to political subdivisions in a covered state, though coverage determinations were not made with respect to such subdivision as a separate unit. In other words, Congress decided that a jurisdiction covered because it was within a covered state need not remain covered for as long as the state did. If the subdivision met the bailout requirements, it could bail out, even if the state could not. In light of these amendments, our logic for denying bailout in City of Rome is no longer applicable to the Voting Rights Act. If anything, that logic compels the opposite conclusion. Bailout and preclearance under subsection 5 are now governed by a principle of symmetry. Given the court's decision in Sheffield that all political units in a covered state are to be treated for subsection 5 purposes as though they were political subdivisions of that state, it follows that they should also be treated as such for purposes of subsection 4A's bailout provisions. The government contends that this reading of Sheffield is mistaken, and that the district is subject to subsection 5 under our decision in Sheffield, not because it is a political subdivision, but because it is a state. That would mean it could bail out only if the whole state could bail out. The assertion that the district is a state is at least counterintuitive. We acknowledge, however, that there has been much confusion over why Sheffield held the city in that case to be covered by the text of subsection 5. This court has not yet settled on the proper construction of the term political subdivision. But after the 1982 amendments, the government's position is untenable. If the district is considered the state, and therefore necessarily subject to preclearance, so long as Texas is covered, then the same must be true of all other subdivisions in the state, including counties. That would render even counties unable to seek bailout so long as their state was covered. But that is the very restriction the 1982 amendments overturned. Nobody denies that counties in a covered state can seek bailout, as several of them have. Because such piecemeal bailout is now permitted, it cannot be true that subsection 5 treats every governmental unit as the state itself. The government's contrary interpretation that helped to render the bailout provision all but a nullity. Since 1982, only 17 jurisdictions out of the more than 12,000 covered political subdivisions have successfully bailed out of the act. It is unlikely that Congress intended the provision to have such limited effect. We therefore hold that all political subdivisions, not only those described in subsection 14C2, are eligible to file a bailout suit. More than 40 years ago, this court concluded that exceptional conditions prevailing in certain parts of the country justified extraordinary legislation otherwise unfamiliar to our federal system. In part due to the success of that legislation, we are now a very different nation. Whether conditions continue to justify such legislation is a difficult constitutional question we do not answer today. We conclude instead that the Voting Rights Act permits all political subdivisions, including the district in this case, to seek relief from its pre-clearance requirements. The judgment of the district court is reversed and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Thomas concurring in the judgment in part and dissenting in part. The appeal presents two questions. First, whether Appellant is entitled to bailout from coverage under the Voting Rights Act of 1965, VRA, and second, whether the preclearance requirements of subsection 5 of the VRA is unconstitutional. Because the court's statutory decision does not provide appellant with full relief, I conclude that this is inappropriate to apply the constitutional avoidance doctrine in this case. I would therefore decide the constitutional issue presented and hold that subsection 5 exceeds Congress's power to enforce the 15th Amendment. The doctrine of constitutional avoidance factors heavily in the court's conclusion that appellant is eligible for bailout as a political subdivision under subsection 4A of the VRA. Regardless of the court's resolution of the statutory question, I am in full agreement that this case raises serious questions concerning the constitutionality of subsection 5 of the VRA. But unlike the court, I do not believe that the doctrine of constitutional avoidance is applicable here. The ultimate relief sought in this case is not bailout eligibility, it is bailout itself. Eligibility for bailout turns on the statutory question addressed by the court. The proper definition of political subdivision in the bailout clauses of subsection 4A of the VRA. Entitlement to bailout, however, requires a covered political subdivision to submit substantial evidence indicating it is not engaging in discrimination in voting on account of race. The court properly declines to give appellant bailout because appellant has not yet proved its compliance with the statutory requirements for such relief. In fact, the record below shows that appellant's factual entitlement to bailout is a vigorously contested issue. Given its resolution of the statutory question, the court has thus correctly remanded the case for resolution of appellant's factual entitlement to bailout. But because the court is not in a position to award appellant bailout, adjudication of the constitutionality of subsection 5, in my view, cannot be avoided. Traditionally, the avoidance canon was not a doctrine under which courts read statutes to avoid mere constitutional doubts. Instead, it commanded courts, when faced with two plausible constructions of a statute, one constitutional and the other unconstitutional, to choose the constitutional reading. To the extent that constitutional avoidance is a worthwhile tool of statutory construction, it is because it allows a court to dispose of an entire case on grounds that do not require the court to pass on a statute's constitutionality. The doctrine avoids decision of constitutional questions where possible, and it permits one lawsuit rather than two to resolve the entire controversy. Absent a determination that appellant is not just eligible for bailout but is entitled to it, this case will not have been entirely disposed of on a non-constitutional ground. Invocation of the doctrine of constitutional avoidance is therefore inappropriate in this case. The doctrine of constitutional avoidance is also unavailable here because an interpretation of subsection 4A that merely makes more political subdivisions eligible for bailout does not render subsection 5 constitutional, and the court notably does not suggest otherwise. Bailout eligibility is a distant prospect for most covered jurisdictions. To obtain bailout, a covered jurisdiction must satisfy numerous objective criteria. It must show that during the previous 10 years, A, no test or device has been used within such state or political subdivision for the purpose or with the effect of denying or abridging the right to vote on account of race or color. B, no final judgment of any court of the United States has determined that denials or abridgments of the right to vote on account of race or color have occurred anywhere in the territory of the covered jurisdiction. C, no federal examiners or observers have been assigned to the covered jurisdiction. D, the covered jurisdiction has fully complied with subsection 5. And E, the Attorney General has not interposed any objection that has not been overturned by final judgment of the court, and no declaratory judgment has been denied under subsection 5. The jurisdiction also has the burden of presenting evidence of minority participation, including evidence of the levels of minority group registration and voting, changes in such levels over time, and disparities between minority group and non-minority group participation. These extensive requirements may be difficult to satisfy, but at least they are objective. The covered jurisdiction seeking bailout must also meet subjective criteria. It must, 1. Have eliminated voting procedures and methods of election which inhibit or dilute equal access to the electoral process. 2. Have engaged in constructive efforts to eliminate intimidation and harassment of persons exercising rights protected under the Act. And 3. Have engaged in other constructive efforts, such as expanded opportunity for convenient registration and voting for every person of voting age, and the appointment of minority persons as election officials throughout the jurisdiction and at all stages of the election and registration process. As a result, a covered jurisdiction meeting each of the objective conditions could nonetheless be denied bailout because it has not, in the subjective view of the United States District Court for the District of Columbia, engaged in sufficiently constructive efforts to expand voting opportunities. Congress, of course, has complete authority to set the terms of bailout, but its promise of a bailout opportunity has, in a great majority of cases, turned out to be no more than a mirage. As the court notes, only a handful of the more than 12,000 covered political subdivisions have successfully bailed out of the Act. The 1982 amendments to the Voting Rights Act, the 1982 amendments to the Voting Rights Act, statutory analysis of the revised bailout provisions, explaining that conditions for termination of coverage have been made so restrictive that bailout will continue to be impossible for most jurisdictions. Accordingly, bailout eligibility does not eliminate the issue of subsection 5's constitutionality. The court quite properly alerts Congress that subsection 5 tests the outer boundaries of its 15th Amendment enforcement authority and may not be constitutional. And although I respect the court's careful approach to this weighty issue, I nevertheless believe that it is necessary to definitively resolve that important question. For the reasons set forth below, I conclude that the lack of current evidence of intentional discrimination with respect to voting renders subsection 5 unconstitutional. The provision can no longer be justified as an appropriate mechanism for enforcement of the 15th Amendment. The government of the United States is one of delegated powers alone. Its authority is defined and limited by the Constitution. All powers not granted to it by that instrument are reserved to the states or to the people. In the specific area of voting rights, this court has consistently recognized that the Constitution gives the states primary authority over the structuring of electoral systems. No function is more essential to the separate and independent existence of the states and their governments than the power to determine within the limits of the Constitution the qualifications of their own voters for state, county, and municipal offices, and the nature of their own machinery for filling local public offices. State autonomy with respect to the machinery of self-government defines the states as sovereign entities rather than mere provincial outposts subject to every dictate of a central governing authority. In the main, the framers of the Constitution intended the states to keep for themselves, as provided in the 10th Amendment, the power to regulate elections. To be sure, state authority over local elections is not absolute under the Constitution. The 15th Amendment guarantees that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. And it grants Congress the authority to enforce these rights by appropriate legislation. The 15th Amendment thus renders unconstitutional any federal or state law that would limit a citizen's access to the ballot on one of the three bases enumerated in the amendment. Nonetheless, because states still retain sovereign authority over their election systems, any measure enacted in furtherance of the 15th Amendment must be closely examined to ensure that its encroachment on state authority in this area is limited to the appropriate enforcement of this ban on discrimination. There is certainly no question that the VRA initially was passed pursuant to Congress's authority under the 15th Amendment. For example, subsections 2 and 4A seek to implement the 15th Amendment's substantive command by creating a private cause of action to enforce subsection 1 of the 15th Amendment, and by banning discriminatory tests and devices in covered jurisdictions. Other provisions of the VRA also directly enforce the 15th Amendment. See subsection 1973H, the elimination of poll taxes that effectively denies certain racial groups the right to vote. Subsection 1973IA, subsection 1A, no person acting under color of law shall fail or refuse to permit any person to vote who is entitled to vote or willfully fail or refuse to tabulate, count, and report such person's vote. Section 5, however, was enacted for a different purpose to prevent covered jurisdictions from circumventing the direct prohibitions imposed by provisions such as subsections 2 and 4A. Section 5 was a response to a common practice in some jurisdictions of staying one step ahead of the federal courts by passing new discriminatory voting laws as soon as the old ones had been struck down. That practice has been possible because each new law remained in effect until the Justice Department or private plaintiffs were able to sustain the burden of proving that the new law, too, was discriminatory. The rebellion against the enfranchisement of blacks in the wake of ratification of the 15th Amendment illustrated the need for increased federal intervention to protect the right to vote. Almost immediately following Reconstruction, blacks attempting to vote were met with coordinated intimidation and violence. By 1872, the legislative and executive branches of state government were once again firmly in the control of white Democrats who resorted to a variety of tactics, including fraud, intimidation, and violence, to take away the vote from blacks despite ratification of the 15th Amendment in 1870. A soon to be victorious mayoral candidate in Wilmington, North Carolina, for example, urged white voters in an 1898 election eve speech: "Go to the polls tomorrow, and if you find an African American out voting, tell him to leave the polls, and if he refuses, kill him, shoot him down in his tracks." This campaign of violence eventually was supplemented and in part replaced by more subtle methods engineered to deny blacks the right to vote. Literacy tests were particularly effective. As of 1890, in states with literacy tests, more than two-thirds of adult African Americans were illiterate, while less than one quarter of the adult whites were unable to read or write. Because prior to the Civil War, most of the slave states made it a crime to teach African Americans how to read or write. Compounding the test's discriminatory impact on blacks, alternative voter qualification laws such as grandfather clauses, property qualifications, and good character tests were enacted to protect those whites who were unable to pass the literacy tests. Literacy tests were unfairly administered. Whites were given easy questions, and blacks were given more difficult questions, such as the number of bubbles in a soap bar, the news contained in a copy of the Peking Daily, the meaning of obscure passages in state constitutions, and the definition of terms such as habeas corpus. The Constitution had declared many of these tests and devices unconstitutional, but case by case eradication was woefully inadequate to ensure that the franchise extended to all citizens regardless of race. As a result, enforcement efforts before the enactment of subsection 5 had rendered the right to vote illusory for blacks in the Jim Crow South. Despite the Civil War's bloody purchase of the 15th Amendment, the reality remained far from the promise. Thus, by 1965, Congress had every reason to conclude that states with a history of disenfranchising voters based on race would continue to do all they could to evade the constitutional ban on voting discrimination. By that time, race-based voting discrimination had infected the electoral process in parts of our country for nearly a century. Moreover, the massive scale of disenfranchisement efforts made case by case enforcement of the 15th Amendment impossible, if not sufficient. It was against this backdrop of historical experience that subsection 5 was first enacted and upheld against a constitutional challenge. As the Katzenbach Court explained, subsection 5, which applied to those states and political subdivisions that had employed discriminatory tests and devices in the previous presidential election, directly targeted the insidious and pervasive evil which had been perpetuated in certain parts of our country through unremitting and ingenious defiance of the Constitution. Congress began work with reliable evidence of actual voting discrimination in a great majority of the states and political subdivisions affected by the new remedies of the Act. According to the court, it was appropriate to radically interfere with control over local elections only in those jurisdictions with a history of discriminatory disenfranchisement, as those were the geographic areas where immediate action seemed necessary. The courts believed it was thus permissible to impose the new remedies on the jurisdictions covered under subsection 4b, at least in the absence of proof that they had been free from substantial voting discrimination in recent years. In upholding subsection 5 in Katzenbach, the court nonetheless noted that the provision was an uncommon exercise of congressional power that would not have been appropriate absent the exceptional conditions and unique circumstances present in the targeted jurisdictions and that at that particular time. In reaching its decision, the court thus refused to simply accept Congress's representation that the extreme measure was necessary to enforce the 15th Amendment. Rather, it closely reviewed the record compiled by Congress to ensure that subsection 5 was appropriate anti-evasion legislation. In doing so, the court highlighted evidence showing that black voter registration rates ran approximately 50 percentage points lower than white voter registration in several states. It also noted that the registration rate for blacks in Alabama rose only from 14.2% to 19.4% between 1958 and 1964. In Louisiana, it barely inched ahead from 31.7 to 31.8% between 1956 and 1965. And in Mississippi, it increased only from 4.4% to 6.4% between 1954 and 1964. The court further observed that voter turnout levels in covered jurisdictions had been at least 12% below the national average in the 1964 presidential election. The statistical evidence confirmed Congress's judgment that the extraordinary stratagem of contriving new rules of various kinds for the sole purpose of perpetuating voter discrimination in the face of adverse federal court decrees was working and could not be defeated through case by case enforcement of the 15th Amendment. This record also clearly supported Congress's predictive judgment that such states might try similar maneuvers in the future in order to evade the remedies for voting discrimination contained in the act itself. These stark statistics, in conjunction with the unrelenting use of discriminatory tests and practices that denied blacks the right to vote, constituted sufficient proof of actual voting discrimination to uphold the preclearance requirement imposed by subsection 5 on the covered jurisdictions as an appropriate exercise of congressional power under the 15th Amendment. It was only under the compulsion of these unique circumstances that Congress responded in a permissibly decisive manner. Several important principles emerged from Katzenbach and the decisions that followed. First, subsection 5 prohibits more state voting practices than those necessarily encompassed by the explicit prohibition on intentional discrimination found in the text of the 15th Amendment. The explicit command of the 15th Amendment is a prohibition on state practices that, in fact, deny individuals the right to vote on account of race, color, or previous condition or previous servitude. In contrast, subsection 5 is the quintessential prophylaxis. It goes beyond the prohibition of the 15th Amendment. It goes beyond the prohibition by the 15th Amendment by suspending all changes to state election law, however innocuous, until they have been pre-cleared by federal authorities in Washington, D.C. The court has freely acknowledged that such legislation is preventative, upholding it based on the view that the Reconstruction Amendments give Congress the power both to remedy and to deter violation of rights guaranteed thereunder by prohibiting a somewhat broader swath of conduct, including that which is not itself forbidden by the amendment's text. Second, because it sweeps more broadly than the substantive command of the 15th Amendment, subsection 5 pushes the outer boundaries of Congress's 15th Amendment enforcement authority. The preclearance requirement both intrudes on the prerogatives of the state and local governments and abridges the voting rights of all citizens in states covered under the Act. Section 5 is a unique requirement that exacts significant federalism costs. Section 5, which authorizes federal intrusion into sensitive areas of state and local policymaking, imposes substantial federalism costs. Internal quotation marks of it. Indeed, subsection 5's preclearance requirement is one of the most extraordinary remedial provisions in the Act, noted for its broad remedies. Even the Department of Justice has described it as a substantial departure from ordinary concepts of our federal system. Its encroachment on states' sovereignty is significant and undeniable. This encroachment is especially troubling because it destroys local control of the means of self-government one of the central values of our polity. More than 40 years after its enactment, this intrusion has become increasingly difficult to justify. Third, to accommodate the tension between the constitutional imperatives of the 15th and 10th Amendments, a balance between allowing the federal government to patrol state voting practices for discrimination and preserving the state's significant interest in self determination, the constitutionality of subsection 5 has always depended on the proven existence of intentional discrimination, so extensive that elimination of it through case by case enforcement would be impossible. The court has never deviated from this understanding. We have explained that prophylactic legislation designed to enforce the Reconstruction Amendments must identify conduct transgressing the substantive provisions it seeks to enforce and be tailored to remedying or preventing such conduct. Congress must establish a history and pattern of constitutional violations to establish the need for subsection 5 by justifying a remedy that pushes the limits of its constitutional authority. As a result, for subsection 5 to withstand renewed constitutional scrutiny, there must be a demonstrated connection between the remedial measures chosen and the evil presented in the record made by Congress when it renewed the VRA. Strong measures appropriate to address one harm may be an unwarranted response to another, lesser one. The extensive pattern of discrimination that led the court to previously uphold subsection 5 as enforcing the 15th Amendment no longer exists. Covered jurisdictions are not now engaged in a systematic campaign to deny black citizens access to the ballot through intimidation and violence. And the days of grandfather clauses, property qualifications, good character tests, and the requirement that registrants understand or interpret certain matter are gone. There is thus currently no concerted effort in these jurisdictions to engage in the unremitting and ingenious defiance of the Constitution that served as the constitutional basis for upholding the uncommon exercise of congressional power embodied in subsection 5. The lack of sufficient evidence that the covered jurisdictions currently engage in the type of discrimination that underlay the enactment of subsection 5 undermines any basis for retaining it. Punishment for long past sins is not a legitimate basis for imposing a forward looking preventative measure that has already served its purpose. Those supporting subsection 5's reenactment argue that without it, these jurisdictions would return to racially discriminatory practices of 30 and 40 years ago. But there is no evidence that public officials stand ready, if given the chance, to again engage in concerted acts of violence, terror, and subterfuge in order to keep minorities from voting. Without such evidence, the charge can only be premised on outdated assumptions about racial attitudes in the covered jurisdictions. Admittedly, that a prophylactic law as broad as subsection 5 is no longer constitutionally justified based on current evidence of discrimination is not a sign of defeat. It is an acknowledgement of victory. The current statistical evidence confirms that the emergency that prompted the enactment of subsection 5 has long since passed. By 2006, the voter registration rates for blacks in Alabama, Louisiana, and Mississippi jumped to 71.8%, 66.9%, and 72.2%, respectively. Therefore, in contrast to the Katzenbach court's finding that the registration of voting age whites ran roughly 50 percentage points or more ahead of African American registration in these states in 1964. Since that time, this disparity has nearly vanished. In 2006, the disparity was only 3 percentage points in Alabama, 8 percentage points in Louisiana, and in Mississippi, black voter registration actually exceeded white voter registration by 1.5 percentage points, 1.5 percentage points. In addition, blacks in these three covered states also have higher registration numbers than the registration rate for whites in non-covered states. Indeed, when reenacting subsection 5 in 2006, Congress evidently understood that the emergency conditions which prompted subsection 5's original enactment no longer exist. The record reveals that many of the first generation barriers to minority voter registration and voter turnout that were in place prior to the VRA have been eliminated. Instead of relying on the kind of evidence that the Katzenbach court had found so persuasive, Congress based reenactment on evidence of what it termed second generation barriers constructed to prevent minority voters from fully participating in the electoral process. But such evidence is not probative of the type of purposeful discrimination that prompted Congress to enact subsection 5 in 1965. For example, Congress relied upon evidence of racially polarized voting within the covered jurisdictions. But racially polarized voting is not evidence of unconstitutional discrimination, and it is not a problem unique to the South. The other evidence relied on by Congress, such as subsection 5 enforcement actions, subsections 2 and 4 lawsuits, and federal examiner and observer coverage, also bears no resemblance to the record initially supporting subsection 5, and is plainly insufficient to sustain such an extraordinary remedy. In sum, evidence of second generation barriers cannot compare to the prevalent and pervasive voting discrimination of the 1960s. This is not to say that voter discrimination is extinct. Indeed, the district court singled out a handful of examples of allegedly discriminatory voting practices from the record made by Congress. But the existence of discrete and isolated incidents of interference with the right to vote has never been sufficient justification for the imposition of subsection 5's extraordinary requirements. From its inception, the statute was promoted as a measure needed to neutralize a coordinated and unrelenting campaign to deny an entire race access to the ballot. Perfect compliance with the 15th Amendment's substantive command is not now, nor has ever been, the yardstick for determining whether Congress has the power to employ broad prophylactic legislation to enforce that amendment. The burden remains with Congress to prove that the extreme circumstances warranting subsection 5's enactment persist today. A record of scattered infringement of the right to vote is not a constitutionally acceptable substitute. In 1870, the 15th Amendment was ratified in order to guarantee that no citizen would be denied the right to vote based on race, color, or previous condition of servitude. Congress passed subsection 5 of the VRA in 1965 because that promise had remained unfulfilled for far too long. But now, more than 40 years later, the violence, intimidation, and subterfuge that led Congress to pass subsection 5 and this court to uphold it no longer remains. An acknowledgment of subsection 5's unconstitutionality represents a fulfillment of the 15th Amendment's promise of full enfranchisement and honors the success achieved by the VRA. Okay, well, that was a good read. As usual, if there's any case you'd like me to read, just drop in the comments and I'd be happy to take a look. Thank you.